out there. It talks about the memorandum of association. It talks about articles of association. It talks about different kinds of companies, private company, public company. It talks about prospectus. It talks about board of directors. It talks about general resolution, special resolution, winding up. So Companies Act is a parent framework as far as corporate governance is concerned. But it is not just the Companies Act which provides a framework for corporate governance, a legal framework for corporate governance. There is also SEBI. So you might all know who SEBI is. It is a Securities and Exchange Board of India. Now, SEBI is a regulatory authority when it comes to all kinds of corporate behavior, all kinds of regulated corporate behavior, right? Now, talking about SEBI, SEBI has a lot of regulations out there, right? So there is one specific regulation which is known as LODR. So LODR stands for Listing Obligation and Disclosure Requirement. It is a specific kind of SEBI regulation which addresses corporate governance. Now, apart from the Companies Act, apart from SEBI, we also have the Competition Act. I mean, a lot of people out there are not that aware about the Competition Act. What exactly is the Competition Act? So the Competition Act 2002 is basically framed for regulating or promoting a healthy competition out there. So what do you mean by healthy competition? Now, we know that there is a lot of, for instance, if we take the case of the mobile networking sector, the mobile networking sector consists of Jio, right? Now, Jio is a major player as far as it comes to network. We also have Idea, Vodafone. Now they have merged together. We also have BSNL. Now, this is a specific framework or a specific marketing field, right? Or a specific market. To be more specific, it is a specific market. Now, Jio, Vodafone, Idea, BSNL, Airtel, they are the players in the market, right? Now, how to make sure that, so this is an oligopolistic market. That means there are only very few players. So how to make sure that when a new organization, for instance, a startup, wants to enter into this market of networking, how to make sure that there is no restriction on entry and exit. Or because there are only very few players in the corporate market, how to make sure that there is no dominance, abuse of dominant position, or there is no unethical marketing behavior, right? Now, all this can be made sure through the Competition Act, because it is ultimately the Competition Act which provides for a healthy competition environment. So I'm not going much into this, but I will just tell you about few sections in the Competition Act which is very significant as far as corporate governance is concerned. One is Section 3. So Section 3 talks about anti-competitive behavior. It talks about horizontal agreement. It talks about vertical agreement. So it is basically a specific section which makes sure that no organization enter into those agreements which would lead to appreciable adverse effect. Appreciable adverse effect means any agreement which is having a negative impact on the economy as a whole, right? That is known as appreciable adverse effect. Now there is Section 4, which talks about abuse of dominant position. This makes sure that, being a dominant player is not an offense, but abusing a dominant position, that is an offense. That is Section 3. Now, Section 5 and Section 6 talks about combination. Combination basically stands for mergers, acquisitions, or any kind of corporate behavior which would actually change the corporate structure of an existing organization. So when we're talking about mergers, or when we're talking about acquisitions, we know that there is a change in the share capital. There is a change in the entire framework of an organization. To a great extent, the Competition Act also provides a framework for corporate governance. So, talking about the legal framework for corporate governance, these are the three legislation which should come into your mind. One is the Companies Act, one is the SEBI LODR regulation, the third is a Competition Act. Now, few of the provisions of Competition Act might have gone beyond your comprehension, but that is all right. I just want to introduce there is a legislation out there which have an impact on the entire corporate governance framework of a private or a public limited company. Now, coming back to the principle, this is the first principle. So this first principle just talks about the fact that every organization out there should be governed by a legal system. And we, as far as India is concerned, we have a very enumerative, a very pervasive legal system which provides a basis for corporate governance, right? Now, this is a case study that I want to bring to your attention. Probably most of you might have heard about it. The infamous case of Satyam Computers. Now, Satyam Computers, this was far back in 2008, 2009, where most of all the board of directors, including the founding director of Satyam Computers, was basically, can you just give me a second? 1 second. Just give me a second. I'm so sorry for this. All right. So sorry for that. Let me just. Yes, I hope the screen is visible again.
Yes, sir, it's visible.
So we were talking about Satyam Computers. So it is a scandal which happened in 2008, 2009, where most of all the board of directors of Satyam Computers was apprehended for inflating the profits. Basically, not just the profit, but also the entire share capital, the value of the entire share capital of Satyam Limited. Most of all the board of directors was arrested for inflating the profit, the share capital, and also for embezzlement of fund. So this have created such a pervasive impact on the failure of the Indian legal system to control or to keep an eye on a lot of organizations out there who is engaging in unethical behavior. So after the Satyam Computers scam came into light, a lot of regulatory changes was made in the Indian corporate legal system. So one was specifically the introduction of the Companies Act 2013. So in 2008, the entire corporate system was governed by the predecessor to the Companies Act of 2013, that is the Companies Act of 1956, used to govern the corporate structure. But there is a lot of inconsistencies or a lot of changes or reforms which was needed in the Companies Act of 1956, which ultimately led to the Companies Act of 2013. The another one was the few changes which was made in the audit committee, rotation of auditors, and the class action suit. Now, audit. So most of you might have heard about audit. Now, audit is a system through which an organization, so there is internal audit and external audit. An internal audit is an audit which is conducted internally by an organization. An external audit is conducted by an auditor who is not related to an organization in any way. Now, the very purpose of auditing is to make sure that the profit and loss account, the balance sheet, and all the financial statements, the cash flow statement, the fund flow statements, all the financial statements of a company are in a proper manner. So the entire purpose of auditing is to make sure that what the company represents out there is actual reality, right? So the entire concept of auditing under the Companies Act was strengthened after the Satyam scam. And class action suit is basically, a suit which is filed in a court of law. I would just help you to understand the concept with the help of minority shareholders. So you might have heard about minority shareholders. So any shareholder who is having less than 50% of stake in an organization is known as minority shareholder. So even then it is divided. The minority shareholders are divided into three kinds. One is having less than 50%, but more than 25%. Then less than 25% to 10%, and those having below 10%. So the minority shareholders, in certain instances, can bring a class action suit. So class action suit, as the name indicates, is a representational suit which is filed in a court of law by a significant number of stakeholders, in this case minority shareholders. So the entire system of filing class action suit was also strengthened after the Satyam scam. Apart from this, there is an SFIO. You might have heard about it. It is known as Serious Fraud Investigation Office. It's a separate department which functions under the Ministry of Industry and Trade and Commerce. That is SFIO, Serious Fraud Investigation Office. So this specific department was formed. And also NFRA, which stands for National Financial Reporting Authority, NFRA. So these are the two departments, or let's say two regulatory agencies which was formed after the Indian experience of corporate scam. Now, this is the first principle. So basically the first principle provides for having to establish a very strong legal system. That's it. So let's move to the second principle. Now, this is the second principle. The second principle is the rights and equitable treatment of shareholders. It basically means every corporate organization should respect the right of its shareholders, should provide equitable treatment of all shareholders. Now, this is, I just told you about the concept of minority shareholders, right? Now, an organization might have different kinds of shareholders. There is equity shareholders, there is preference shareholders, there is minority shareholders. So equitable shareholders are those who is having a significant share in an organization, who are able to take almost all major decisions in an organization. While minority shareholders, because their voting percentage is less than 50, they are not able to have a significant impact on the decisions of the company. But it does not mean the requirements of the minority shareholders should be disregarded by the company. Now, if you're looking into the Companies Act of 2013, there are very special provisions. For instance, there is a provision which talks about mismanagement. This specific provision could be invoked by the minority shareholders whenever they feel a company is going in the wrong direction, or the equity shareholders are taking decisions which are not in the best interest of the company. So in such cases, they could invoke the provision of oppression and mismanagement. This is a specific provision curated for the minority shareholders. I have one case study over here. Again, this is a very significant case which culminated in 2018. So there was a legal battle between one of the terminated shareholders in Tata and the Tata Sons. So basically, Mistry, he was a director of Tata's son, in 2016-17, he was terminated. He was terminated from the board of directors. So he brought an action against Tata Sun Limited, basically saying that he have been terminated without following proper procedures. Now, it went through, the suit was prima facie, the suit was filed in NCLT, which is National Company Law Tribunal. So NCLT gave a decision in favor of Tata Sun. Then an appeal went to NCALT, which is the National Company Law Appellate Tribunal. Now, NCALT reversed the decision of NCLT and said that it was a wrong decision on the part of Tata Sun to terminate Mr. Mistry without following proper procedures. And again, Tata Sun have filed a suit in an appeal in the Supreme Court, because from NCALT, the appeal goes directly to the Supreme Court. The Supreme Court gave a decision in favor of Tata Sun, but certain observations was made by the Supreme Court, which is very significant as far as this second principle is concerned. The Supreme Court have said the board of directors have a lot of autonomy, specifically with relation to appointment of a director, termination of a director. Those are internal practices, and a court of law cannot usually impose a question on why a person is terminated. At the same time, the Supreme Court also made it very clear, even if there is autonomy to the board of directors, they have to exercise their functions in a very balanced manner, making sure that they follow all the principles of corporate governance. So even if they make a decision, the board of directors have a responsibility not only to the management, but also to different stakeholders, including the shareholders, including the minority shareholders, including the employees, including the society as a large. So they have to make sure that every single decision that they make is made in a balanced way, right? Now, it is in this context, this principle becomes very important. That is the second principle, the second principle of corporate governance, which basically provides for the fact that an organization should respect all its shareholders, all its stakeholders, in a very equitable, in a very balanced manner, right? Now, let's just see the third principle of corporate governance, which is also one of the very significant principle: institutional investors, stock market, and other intermediaries, right? Now, you might be thinking, who is this institutional investor? How is an institutional investor different from a normal investor? Now, you might have heard about mutual fund. So most of you even might have investment in HDFC mutual fund or SBI mutual fund. So what exactly is mutual fund? So mutual fund is when, as the name indicates, it is when an organization, for instance, let's say HDFC for that matter, invest in a number of stock, not just one share, not just one stock, but a culmination of stocks out there, so that the risk factor is reduced to a great extent and the return is much more. So institutional investor is not an individual investor, but they're an organization which is representing the interest of a large number of shareholders. For instance, HDFC mutual fund, HDFC is an institutional investor, but they carry the representations of all the shareholders who have invested in their mutual fund, right? Now, an organization, as far as an organization is concerned, it is also having a certain deal of responsibility to institutional investors, to stock market, and also to intermediaries. Now, stock market, so we have heard about the National Stock Exchange, the Bombay Stock Exchange, the listed company. So whenever a company is known as a listed company, they have an enhanced form of responsibility. So what is a listed company? A listed company is a company which is having one of at least few of their shares listed in any of the stock exchanges. Now, a listed company is subjected to more scrutiny by SEBI and other regulators. So this third principle provides for the responsibility towards the institutional investors. Now, institutional investors is also having a responsibility. Now, what is that responsibility? Because the institutional investors are also having voting rights, right? Now, when these institutional investors are exercising the voting rights in an organization, they always have to make sure that they are acting in a collective and accountable manner, because they are not one organization. They are representing the interest of thousands or hundreds of investors out there. So every single voting which is done by an institutional investor should be made in a transparent manner. It should be available in the public domain so that anyone could check out, okay, why they have exercised this specific voting right? So that is about institutional investors, stock market, and other intermediaries. So this is the third principle. So there is also a case study with relation to this. Now, this is the case study of Yes Bank. Now we know Yes Bank. So now Yes Bank have came up with a lot of, their stock have increased to a great extent, and they're providing a lot of benefits to their depositors and investors out there. But would you believe when I tell you there was a time when Yes Bank almost ceased to exist? So this was far back in 2018, 2019. So this all started with the Reserve Bank of India refusing to extend the appointment of CEO Rana Kapoor. Now, do you know that as far as banking companies are concerned, RBI have a major role to play with relation to the appointment of CEO and the key managerial personnel. So this usually happens in the banking business, especially commercial bank. So whenever a commercial bank have to appoint a CEO or a key managing personnel, they have to take the permission of RBI. Now, with relation to Yes Bank, RBI refused to extend the term of Mr. Rana Kapoor. So after this, a lot of irregularities in Yes Bank came into light. Now, for the first time, Yes Bank have published a statement where they were incurring significant number of losses. They are almost in the verge of winding up. So this is when RBI immediately have proclaimed moratorium for Yes Bank. So moratorium. So when RBI declare moratorium, it means that no suit or no case can be filed against an organization in any court of law in India, as far as a banking organization is concerned. So RBI have declared a moratorium for Yes Bank and gave it a certain amount of time to rebuild. So this Yes Bank went through an entire rehabilitation stage where they had to sell a lot of their stock. They have to reinvest and invite new depositors. But at the end of the day, the initiative of RBI and the government at that point of time for revamping Yes Bank came to a positive end, positive connotation. Yes Bank caught up, and now Yes Bank is out there doing a great job. And if you look into their profit and loss account, it is actually showing an increase in net profit. Now what is the lesson which we are learning out here is that whenever an organization is engaging in any kind of business, whether it is banking business, non-banking business, any kind of commercial business, they have to be completely transparent to the regulatory agencies, right? Now, this is what the third principle symbolizes. That is, even if an organization has to be completely transparent to all its stakeholders, because an organization is not existing in an island by itself. It is basically an agency which is at the central point of a society. That means every action of an organization, every action of the society is having a cumulative or a correlative impact on the actions of an organization to an extent. Now, after the Yes Bank incident, the RBI have increased its oversight on almost all commercial banks. RBI have made for mandatory disclosure of almost all commercial banks and made it very mandatory for commercial banks to get the permission of RBI before they appoint any higher management personnel or key managerial personnel, as we call it, or any member of the board of directors. Before it is appointed, they have to get the special permission of RBI, right? And yes, so this is also a case study out there, which also symbolizes the significance of corporate governance. Now, going towards the next principle, this is disclosure and transparency. I don't think this needs much understanding, because we know that whenever an organization, at the end of a financial year, most of the organizations out there, they completely disclose their balance sheet, their profit and loss account of that specific financial year, so that we are able to understand whether the organization is going in the right direction. And it is after this complete disclosure, an investor makes a decision whether to invest in that specific organization or not, right? Now, this is a disclosure and transparency, and this is also very, very significant principle. There is also one case study associated with it. This is a case of IL and FS Group. Now, IL and FS Group have created another, huge impact on the corporate sector, whose underlying impact was felt throughout the economy for some time. Now, what happened with IL and FS Group was that they had an immense debt of 91,000 crore, right? So when they disclosed their accounts in the recent years, it came into light that they have defaulted in the payment of almost the payments which they have taken from a lot of commercial bank, a lot of investment banks out there, a lot of banking companies out there. So they also had to go through a lot of legal procedures to be back on track. Now, few reforms which happened after the IL and FS Group, the huge debt that they've incurred. After that, the Corporate Affairs Ministry have called for a widespread revamping of the entire corporate structure. So before, RBI used to have a significant control only on banking companies. But after this, even the NBFC, which is a non-banking financial corporations, they were also brought under the strict control of the Reserve Bank of India, right? And also the complete disclosure with relation to the impact an organization is having on the economy. So we call it CSR now, that is Corporate Social Initiative, Corporate Social Responsibility, CSR. So every company have to now mandatorily disclose the kind of actions that they have undertaken as a part of their CSR initiatives. And also, you might have heard about the term greenwashing. So greenwashing is when a lot of companies out there, they kind of manipulate different stakeholders by saying that they have invested a lot in renewable energy or green fuel, so that they are contributing towards sustainable development. But in actual practice, they might have all been using this fossil fuel, and it is just to create a periphery that these organizations make such false claim. So it is after this a lot of regulatory agencies made it mandatory for the business organization to disclose not just a CSR initiative, but also something which is known as, if I take you to the slide, you can see over here, there is something known as ESG. So ESG stands for environmental and social governance. Under the environmental and social governance, every organization have to significantly invest a part of their profit in such initiatives which is beneficial for the environment, beneficial for the society. So under this, something known as a business responsibility and sustainability reporting. So it is known as BRSR. So BRSR is a disclosure which is made by a lot of companies at the end of the financial year, where they indicate to what extent they have invested in fossil, they have not invested in fossil fuel, but how, to what extent they have reduced their allegiance to fossil fuel, and to what extent they have invested in greener, more sustainable fuel. So all these details and factors could be found in the business responsibility and sustainability reporting, right? Now, this is the principle on disclosure and transparency. Now, the fifth principle is the responsibility of the board. So this I have already told you about the board of directors and the kind of responsibility the board of directors are having on the economy as a whole. So now we know that under the Companies Act of 2013, it is very necessary to have a very diversified board of directors. So diversified board of directors means every company should have independent directors. Every company should have non-executive directors. Every company should have a woman director. So all this regulations have been made, have been brought into picture. A lot of companies out there, recently the HDFC Bank have increased the number of women directors in their board of directors. So to diversify, not just to diversify, also to show that the board of directors are able to make more responsible decisions. Because when the board of directors consists of people from different genders, different background, not just the executive directors, but also the non-executive and independent directors, they are able to make more informed decision, which is beneficial to all the stakeholders. So this is the fifth principle. That's the responsibility of the board. Now, this is a case study of Infosys. So Infosys in the last few years, there was an anonymous employee of Infosys, which filed a case against the upper management of Infosys, basically contending that upper management was involved in insider trading. They were also involved in a lot of unethical practices. Now, at the end of the day, after a lot of investigation, Infosys have opened up investigation. They have conducted internal investigation. They have also opened up their organization for external investigation by different regulatory agencies out there. But anyway, at the end of the day, Infosys got a clean chit. But that is not the learning perspective here. The learning perspective here is every organization should have a scheme through which their employees are able to have a trust on their board of directors. And also, most of all the companies should have a whistleblower scheme. So whistleblower protection or whistleblower scheme means if any member of the board of directors or any member of the employee, they want to report anything unethical which is happening inside the company, even though they are a part of it, but they want to come out clean. Certain legal protection should be provided to them, both by the regulatory agencies and also by the companies. So this is known as a whistleblower protection. So after this Infosys allegations, the Ministry of Corporate Affairs have strengthened their whistleblower scheme. That is, they basically made sure that anyone out there without any fear could bring out any unethical practices which is happening inside their organization to the regulatory agencies without any fear of legal persecution. This is known as a whistleblower protection. So that is about the responsibility of the board of directors. And the final and the most pertinent principle, this is the sixth principle. It is a sustainability and resilience principle. So we know that Even recently, the UN and all the G20 or Asian group or any other international organization, they have been stressing for a sustainable future, or they have been advocating for sustainable practices, not just by individuals but also by organizations. So now there's a responsibility and a proliferated responsibility on the organizations to make sure every single action which is taken by them is sustainable in nature, right? So this is where the concept of ESG comes into picture. I've already introduced to you the concept of ESG. So ESG stands for environmental, social, governance. So now each of organizations out there, they have ESG indicators. ESG indicators means how much an organization contribute in a better way to sustainability. They will have more ESG points. They will have more ESG indicators. So and now a lot of investors out there, even when I am also investing in a specific mutual fund or a specific stock for that matter, I will always make sure that the organization that I am investing in all is following, or they have a history of sustainable practices, that they have reduced their significance, or they have reduced their reliance on fossil fuel, and they're investing more in greener, sustainable energy, and they have reduced their carbon footprints. So there is a lot of investors out there who basically invest in only those companies which are following sustainable practices. It is for this purpose a ESG disclosure was introduced. ESG disclosure is compulsory for the leading 1,500 companies. So if you're looking into the ranking of the companies with relation to the number of investment that they receive, the first 1,500 companies, it is mandatory for them to completely disclose their practices, whatever they are doing out there, which is relating to ecology, which is relating to environment. They have to completely disclose it. On the basis of this, they are given an ESG score. So based on this ESG score, the investors can decide whether they should invest in a specific organization or not. Now, all the case studies that I've introduced so far, even if it is a Satyam Computers, even if it is a Tata dispute, even if it is the disputes with relation to Yes Bank, all was having a negative connotation. But the case study that I'm introducing right now is having a positive connotation. So this is with relation to Reliance Industries. Now, Reliance Industries have engaged in a path-breaking behavior and set in a trend for all the companies out there, because Reliance Industries have completely decided to reduce their reliance on fossil fuel. And they have even said that within the few years, they would have a net zero reliance on fossil fuel, and they will completely shift to green hydrogen, solar, and ESG linked investment. And they are also ready to completely disclose all their documents with relation to ESG practices. They have also said by the year 2035, they will have zero carbon emissions. They will have zero carbon footprints across their business organizations, right? So based on this, the Ministry of Commerce and Trade and also SEBI have introduced the reporting known as BRSR. Now, BRSR stands for Business Responsibility and Sustainability Reporting. This is mandatory for the top 1,000 listed companies from the financial year 2020-2023. So BRSR is simply a disclosure. It is a document. So at the end of every financial year, business organization disclose their profit and loss account, disclose their balance sheet. Similarly, they will also disclose their BRSR report, which basically shows uh, whether their organization have invested in any green hydrogen, solar fuel, any greener sustainable fuel, or to what extent that organization have invested in fossil fuels. All this is disclosed through the BRSR report. Now, apart from the BRSR report, there is something known as BRSR core. The BRSR core is compulsory for the top 150 companies. Now, the difference between BRSR and BRSR core is BRSR is more general in nature. BRSR core is more specific in nature. It is more stricter in nature. In BRSR, the company can make an internal disclosure of their sustainable practices. While in BRSR core, every disclosure which is made by a company has to be approved by a third party organization, like an external auditor. They have to approve the disclosures made by an organization. This is known as BRSR core. This is compulsory for the top 150 company, while BRSR was compulsory for top 1,000 companies, right? Now, this concept of ESG, the concept of BRSR reporting and all this, it aligns with our 6th OECD principle, that is sustainability and resilience principle. That was the final principle that we learned with relation to OECD, right? Now, regulatory framework, I've given a brief idea about the regulatory framework in India. One is the Companies Act. One is the SEBI LODR regulation, that is SEBI listing obligation and disclosure requirement regulations 2015. So these are the two major legal framework out there, government.